Ukrainian law at ease.
Hello, everyone. My name is Marichka Ignatova, and you are listening to my podcast, Ukrainian Law at Ease. This is already the 23rd episode so far, and in this episode, with the help of my guest speaker expert and me, you will learn a little bit more about international law of the sea, which is also known as maritime law. Please welcome the expert, Olesia Gorbun, PhD candidate at the Institute of the International and European Union Law in the Law School at Mykolas Romeris University, which is located in Vilnius, Lithuania. She is also the invited member of the Scientific Expert Council of International Law at Yaroslav Mudryi National Law University in Kharkiv, Ukraine. Her dissertation topic, her research basically, is concerning the influence of the Crimean occupation on the effective dispute resolution under the 1982 United Nations Convention on the Law of the Sea. A very interesting and I would say maybe complicated introduction, but please be assured that Olesia is, I would say, the genius and true expert concerning the international law of the sea. Prior to we start, I would like to remind you that neither this episode nor the podcast in general are legal consultations. So should you have any question, any request for legal assistance, please contact your lawyer or any lawyer you would like to. Olesia, hello and welcome. Thank you for joining me in this on this Saturday morning. I'm really looking forward to talking to you about such interesting and I would say sophisticated topic. And I believe that this episode will be beneficial for anyone, even non-lawyers, who would like to know more about international law of the sea.
Hello, thank you for such a nice introduction. It's nice to hear you too. Indeed, I guess this will be also useful not only for lawyers, but the ones who will be interested in general to get some general knowledge of international law of the sea. And in general, it's also would be interesting for someone who interested in even in geography, because we will talk a bit more through the worldwide and how everything is regulated. I'll try my best to make it as I don't think it's difficult, to be honest, but I make it simpler and easier to understand. So let's have usual normal conversation. Yeah.
Great. So let's start talking about international law of the sea. I believe it would be nice if we outline and discuss some general provisions of the international law of the sea, right? So what are the probably main definitions, notions, what is the maritime law, and is it different from the law of the sea? Why the law of the sea important, and so on. So could you please elaborate more on this?
Yeah, sure. Okay, first of all, why we call it international law of the sea and what the difference between maritime law is. International law of the sea, it's talking about more about the public aspects of this of the regulation of the sea, while maritime law is more about the private field. So, for example, when you it's still, let's put it this way, it's ongoing discussion between scientists and researchers about whether they are similar or they have how many difference they have. I know for sure in Ukraine there's different school of law, the school of an opinion that okay, look, maritime law is only private, which deals with for example, relationships with seafarers, and the company who employed us. So it's more even involving some labor law. When law of the sea is more about the public. So, for example, the relationships with the states, how they regulate their borders in the sea, because it's also important. So. To be precise, why exactly it's important? It's important because it regulates some relationships between either people, either states, and it's nice to have something where you can look into for guidelines. So that's what about the international law of the sea. And what's the most significant about the law of the sea is as everyone, I guess, who is studying law, and especially particularly international law, it's kind of difficult to find any regulations about the responsibility of states. And the convention, which United Nations Convention of the Law of the Sea of 1982, it speaks loudly about it has the provision about the compulsory dispute settlement resolution, and it's mean the binding decision for the parties participating in this resolution. So it's particularly significant. It has the binding decision, which leads to which can have the the decision which will have make the state responsible for their actions. But it's only connects to the the law of the sea.
And who is entitled to enforce this binding decision? I believe it's neither of the states, which are the parties to the dispute, right? It should be some probably independent authority or body who would enforce it.
I wouldn't say there is like a special organ or authority who is about the enforcement. There is when a state joining the convention, there is approximately 4 means of means to settle the dispute, and the state choose which means it wants to in the future cases to be settled. For example, it could be Permanent Court of Arbitration, ICJ, or it could be International Tribunal Law of the Sea, or it could be the tribunal initiated by particular provisions of the UNCLOS. So the tribunal, so there is while they're joining the convention, the state takes responsibility to accept this binding decision and to follow its ruling. So it means more on the responsibility of the state to do this while they're joining the convention.
Okay, great. Thank you for this clarification. I know that there are certain general and probably the most important definitions in the law of the sea. Could you please tell us about such definitions? What are they, and what is the meaning of these definitions that most of the parties, most of the countries operate within the law of the sea?
Yeah, sure. The thing which I wanted to add, I'm sorry, to the last point is that it's sorry, just probably get nervous.
That's all right. That's totally fine. We're just two lawyers talking about law of the sea. Well, probably you are more talking than me because you are the expert here. So yeah, no worries. This is just a simple conversation.
Yeah. The thing about the law in general, I think all the things there, the more you learn, the more you feel like, oh, there is something more to learn. So it's it's like it's constant process of
Especially when
learning.
you're doing a PhD and you do a lot of research on it. There is always something you have to discover, to research, of course. I know that feeling.
Yeah, that's true. That's true. Okay, so talking about the definition, the law of the sea, it's something very. It's basically you can find all of them in the convention. To simplify not to tell United Nations Convention of the Law of the Sea, I'll be just telling UNCLOS. That's like a short name of it. It states about the definition. Basically, it's about the baselines. So. And territorial sea, internal waters, exclusive economic zone, and high sea. What is this definition is about? It's mostly about how we actually delimit the sea. So we have, for example, in the land, we have territory, and we have the marks where, okay, this is the one state territory, this is another state territory, and the same happens in the sea. However, even Grotius say that the sea, it should be for everyone. It's like so we have the high seas, like freedom of basically it's the heritage of the whole for everyone. The high
So
sea is like
everyone
the
can use
most.
it and have access to the sea.
Yeah, for sure. There is still some limitation and regulations about the high sea, but they're very like limited. The less then we have exclusive economic zone, which is about 200 nautical miles from the baselines, from the territory. So it's like a bit less, for the whole, like for international community to enjoy the rights. And then we have territorial sea, which lasts, and the internal water, which is entirely the jurisdiction, the jurisdiction of the coast states, and the baseline, which actually from which this zones are measured. So starting from the beginning, the baselines is it's the point where the water hits the land. And it's interesting because all of like everyone knows from the basic geography or understanding of the world, there is the low tide and the high tide. So sometimes the sea reach one point, and at some point it's reach other point, like other point on the landscape. Talking about this, it was decided, like it was established that the baseline will be low tide. So when the water reached the farthest from the land. Why it happens? It's easy because each country has wants to have more territory, land territory, which has like full jurisdiction. So that's like one of the point. And you would be surprised, like if you check, for example, just Google it. In Panama, they have a Playa Palenque, something like this, you like when you see it in the high tide and the low tide, it's like two different places. It looks like the same happens in England, and if I recall correctly, in Canada, in Bay Fundy is like the most highest difference between this high tide and low tide.
How much high it can be? Is it like several meters or even kilometers?
To be honest, I don't remember exact
Okay, that's fine.
numbers. But
No,
it's some
I'm
like
just
it's
being
visible.
curious.
Like, yeah, it's visible. Just Google image, everything. Like just like it's very
Okay,
impressive to see.
so let's just leave it as a quest for our listeners, for our audience,
Oh,
so they can just go and Google it right away after listening to that, and probably just type us in the comments to this episode. What are your findings concerning the difference between these 2 points?
yeah, I believe the more you listen, like it's something you have to learn by yourself to remember something. So I
Sure,
guess would be
sure.
perfect. And continue the topic, we like the baseline, so we know how to measure the maritime zones, and then we have internal waters. It's interesting. It's always interesting. From one side of view, internal waters, we can include the water which are within inland waters. So, for example, lakes, like I don't know, the rivers in the territory, but they're not regulated by UNCLOS at all. But there is interesting approach which tells us there is internal waters and there is inland waters. So, meaning by inland, we're talking about the waters which were within the land border of the state, and the internal waters is a bit for example, the ones which are like bigger historical waters, which are considered internal waters of state, but it happens not because it's inland water, but because it's used to be like this for ages. No one was, not other state had something, against it, so it became internal waters. However, from the baseline, we measure not the internal waters like the zone, but we measure the territorial sea, which has like 12 nautical miles. Then from 12 nautical miles from the baseline, again, we measure 200 nautical miles. And it's interesting for general that nautical miles are not the same with the kilometers. So, for example, 1 kilometer have only 0.5 nautical miles, and approximately 1 nautical mile has like something around 1.85 approximately kilometers. Why it happened? Because of the cartography and the navigation in the sea. For when you have they used to have maps, so it's more convenient for them to use nautical miles rather than calculate everything through the kilometers.
Well, and not every state actually uses a metrical system in order to, I don't know, to limit or to count the distance, right? So I believe that this is just a specific measurement for the seas, for the oceans, and all this maritime things.
Yeah, especially when you measure it to delimit the territory, like the delimitation of the zones, it's nautical miles. Yeah, it's also interesting because it's common that territorial sea is 12 nautical miles, and Ukraine has 12 nautical miles. And if you look in the countries which next to the Ukraine, they also have 12 nautical miles. But for example, talking about the Black Sea region, the Turkey in the Black Sea, it has 12 nautical miles, while in the Aegean Sea, related to the Greece, Turkey insists about the 6 nautical miles, while Greece insists about the 12, as it's common, as it's provided by convention, etc. It happens because Greece and Aegean Sea has a lot of islands, as well as Turkey. But if calculate the amount of the, because why it's important? Because territorial sea has for example, in territorial sea, other state has only the ability of the innocent passage, which is very limited. You have not to stop. You just have to pass. That's it. Not intervening, not going anything closer, not stopping, while not even not fishing. Especially, it's territorial sea has jurisdiction of the coastal state. One exclusive economic zone has a freedom of navigation when everyone can freely navigate, etc. So when we talk about the difference between 6 nautical miles as a territorial sea and 12 nautical miles, if the Aegean Sea will be 6 nautical miles, will be approximately 50% of international waters when we have freedom of navigation. And if it will be 12 nautical miles, there will be only approximately 20% of the high sea, not high sea, the exclusive economic zones, and they have the special distance. When for sure Greece wants to have 12 nautical miles to have more power in the region, and Turkey is no. Particularly in this case, we want to have it 6 nautical miles. And it's interesting also from the point that different countries. Most of the country has 12 nautical miles. There is only limited amount of the countries who claims, for example, 30 nautical miles or 200 even nautical miles for the territorial sea. So imagine there's exclusive economic zone of 200 nautical miles of one country, and there is another country who claims territorial sea for 200 nautical miles. However, such countries, such decisions, very unpopular. For example, the Benin, Peru, Somalia still has at the moment 200 nautical miles. While the Togo, Ecuador, the African countries, Togo, for example, claimed 30 nautical miles, but not relatively recently. I think in 2019 they approved that territorial sea of our country is 12 nautical miles, and then the Ecuador also from 200 nautical miles. In 2012, they say that again 12 nautical miles. So it's becoming more standardized, more as a standard.
Yeah. So is it the state itself who is allowed to decide the distance, how long the exclusive, for example, the exclusive economic zone can be, as you said, that there is the difference in the distance, or is it someone else who decides and approves this decision?
No, there is the United Nations Convention who says directly that, the state, if you're joining it, you have to follow the rules. And secondly, talking about whether the states decide or not, the states calculate the distance and providing its like it's called the like baseline points. So it's called like basically the it's work for the cartographers, it's work for the engineers to point out where exactly through in the map there is the point where the baseline is measuring. And they submitted it to the United Nations, and this document becomes official. So yeah, and in the case of the disputes between the two countries, for example, one claiming this like, I don't know if you remember, there was disputes between Romania with Ukraine. We were claiming about some kind of like there was some disagreements about it. The court, like if countries asking, the court could make decision about it.
Oh, yeah, of
It's,
course.
it's also the point how convention was able to be so strong and successful at the point when the countries, the states are joining the convention, they can limit the jurisdiction of the dispute, like the dispute settlement. For example, there is the article which says that the states doesn't allow to settle the disputes or evaluate the disputes related to the delimitation or to some like very very difficult and harsh topics, such kind of the borders, the sovereignty of the states. There is like historical titles, or for example, when it comes to the enforcement or military operations, something like this. So they also can limit the jurisdiction.
Speaking about the disputes and settlement of the disputes, could you please tell a little bit about different maritime zones and maritime regimes? What are the zones and what are the regimes? And
Sure.
what is the jurisdiction in these two aspects, the zones and the regimes?
The zones is the one we just mentioned. It's like definitions, like the zone, like territorial sea, exclusive economic zone, like high sea. It's like it's considered the maritime zones. And maritime regimes is the ones like where you can see the obligation and the rights and obligation of states in this regard. So, for example, in territorial sea, it's mostly jurisdiction of the coastal state when the foreign states has right of the innocent passage. When the exclusive economic zone has maritime zone, which has the regime of freedom of navigation. There's also like much more freedoms, like freedom of freedom of fishing. Like there's like pretty much a lot of them, talking and also about the regimes. For example, if it comes to the regime of the one zone I haven't mentioned is international the zone, like international straits for the navigation. It has the regime of transit passage, so it's similar to the one which has like freedom of it's it's just basically it's a regime which has a stating about the rights and the obligation of foreigners and the local states.
So
It also has to be. Sorry, I just
Yeah,
mentioned the last
that's
point.
fine. Please go on.
Yeah, I also will mention the important thing that the landlocked states are enjoying the innocent passage, like they can go through the internal waters of the state to have ability to access the international waters. So it's also like kind of a regime which allows landlocked states go through the basically through the water where the other states like not allowed to go.
Okay.
I interrupted you. So sorry.
I was just going to refer to the straits, right? So as you mentioned, the straits are the waters in the regime of passage, of free passage, of transfer. So you basically are allowed just to go through it. So, for example, the Panama Canal, right, as the example of the international strait, allows you to go from one ocean to the other ocean, so or from one hemisphere to the other hemisphere, if I'm not mistaken. So, what is also interesting about the straits? What are the peculiarities? How are they regulated? Who own, if I may say so, the strait, and what countries and how countries do settle any disputes related to the straits?
Okay. First of all, it's difficult to say so somebody owns the strait. It could be says it's possible to say about because you mentioned the Panama Canal. There is also Suez Canal, which are actually artificial straits which were built. For example, the Suez Canal is considered like owned and maintained by Suez Canal Authority of Egypt. And talking about the straits, like first of all, it has to be very clear that in general, what we understand what a strait is. Strait is like we coming from one part of the sea to another part, and there's like a snow narrow like passage which allows us to go to another part. For the convention, for UNCLOS, there has to be certain amount of requirements to meet to be the strait will be recognized as an international strait. For example, such strait as a Turkish strait, which we know is like there is actually Turkish strait consists of two straits. It's Dardanelles and Bosphorus. It's historically it was regulated, and it came to that it was external water of Turkey, but they made convention, Montreal Convention regarding the regime of Turkish Strait, and this straits, the passage of it, the zone of it became as a part of the regime of international waters. So foreign ships could come, vessels through the straits without any limitation. Why international strait regulated by UNCLOS is important, because it allows people, the countries, like not only who are in the region, to pass through the strait. They have to have international importance. So this strait should come from the exclusive economic zone, where it's the freedom of navigation to sea to another part of where is an exclusive economic zone or high sea. So it should be internationally relevant strait. It also has to connect. It also has between itself has to have territorial sea within the strait. So we can say international strait meaning geographically, when, for example, Kerch Strait could be geographically for sure considered as an international strait, just because it's like a narrow passage through from Black Sea to the Azov Sea or vice versa, and it also includes mostly the ships of Russian and Ukrainian under Ukrainian flag. However, we have to if the Azov Sea is like internal, like has a status of their internal historical sea, it's not international strait under UNCLOS provisions. And it's also like let's put it this way: the more I know, the more I learn, the more it's interesting it becomes. I was writing 2018, I was writing master thesis on the status of the Kerch Strait. So I was researching about what this Kerch Strait is, like whether it's international strait, whether it's the water, like it has a more historical strait. And at some point, I was asking my supervisor, because there was arguments in favor of like it has a historical meaning, or it might become an international strait. From that moment, I decided that okay, it's supposed to be more historical strait, because I thought that it's more arguments in this favor. However, a couple of years ago, when for example, the Ukrainian approach started to be available online, and there's a dispute, so basically the Ukrainian officials' authority view has become available. They claim the Kerch Strait as an international strait for navigation under UNCLOS. While Russian Federation says that no, it's like historical strait. So it's very. Tell us.
Yeah, I just wanted to ask. So, what are the arguments in favor of that Kerch Strait is the international strait, as Ukrainian authorities claim it?
It claims because first of all, to define Kerch Strait as an international under UNCLOS, you have to have a passage from one part of the sea which has either high sea or the exclusive economic zone to another exclusive economic zone. So it leads us to the question, what the status of Azov Sea? And Azov Sea in this regard is not like, in some sources you can find this, it used to be internal waters of USSR till the dissolution of USSR. And it used to be, but then dissolution happens, and then Ukraine became independent. The Russian Federation became independent, and from that moment there was negotiations, like rounds of negotiations between Ukrainian and Russian authorities and representatives. At one point in late, like just before 2000, Ukraine submitted to United Nations the limitation of Azov Sea, stating its territorial sea, exclusive economic zone. Russian Federation never agreed on that. So till recently, like from the open sources available, it was very unclear what's Ukrainian opinion about the Azov Sea. Whether it's they think they agree of having like internal waters between Ukraine and Russia or not, and in favor of considering Azov Sea as having full delimitation under UNCLOS. The Ukraine, there is first of all, the Azov Sea is kind of a big one. It's not something which you can see from the case, also some part of the, I guess, a home reading. You can check the Gulf of Fonseca or the Gulf of Piran. The Gulf of Fonseca, it's the Gulf which was the dispute between the limitation of the waters was solved by tribunal. It's the countries were like previous former colonies of Spain, if I'm not remember. There was a Nicaragua involved, the Honduras and Salvador, and it was solved and was concluded that it has special regime, as the same as happened with the Bay of Piran, I think, with the Croatian and Croatian Horvatia. No. Anyway, so
the isn't it?
No, for sure no.
Okay.
So the point here, that Azov Sea, because it's so huge, it cannot be recognized as internal waters of one state. Moreover, it's under convention, it's considered as enclosed. There's provision about semi-enclosed seas and enclosed seas, so it comes under that provision. Basically, it could be considered as having exclusive economic zone, but there is a dispute going on. There is no certain answer on it, so it basically depends whether there will be enough arguments in favor of it having international status or not. So that's the answer to the question. It mainly depends on the status of the Azov Sea. We could say whether Kerch Strait could be the international strait and UNCLOS or not, because from the perspective of the recognizing it doesn't have any agreements between Ukraine and Russia about the specific regulation of the navigation through it. It has, in 2004 was some agreement, but Ukraine points out that there were no the agreement was valid, but it before, but the first thing which should be done, it's delimitation through the Kerch Strait and the Azov Sea, which never have been done. And now Russia claimed that Kerch Strait is internal waters of Russian Federation, starting from 2014, unfortunately, which is not, Ukraine doesn't support this position, neither I. Yeah, that's pretty much the explanation. It's a complex issue. You cannot look into it through the one perspective. There's a lot of small issue which has to be considered. So basically, you have to look from different perspective and to see the whole point. So, yeah.
Well, following that, of course, this is the complicated issue, and I believe that this is the ground for various disputes. I also believe that in the whole world there are other international law of the sea disputes. Maybe you can tell our audience about maybe the most outstanding, significant, and interesting disputes and settlements concerning the international law of the sea.
Yeah, sure. The most the outstanding is a Fisher case. It's between that was actually even before the convention. It was between Norway and Great Britain, and there were that's how basically the standing was because it's provides it settled the customary law into the decision, and it provides some of base kind of some research some researchers are considering it as provides a base for the further possibility to actually create the United Nations Convention. It provides definitions of strait baseline. It provides it's helped further archipelagic states to be able to make their own internal waters, territorial sea territory, like the maritime zones. Talking about the other disputes, it's also as we're both Ukrainian, would make sense to mention Chagos Maritime Protected Area Arbitration and also the South China Sea Arbitration. Because it's in the international community, it's considered as a very relevant disputes to our own disputes between Ukraine and Russia Federation, which called the disputes concerning coastal state rights in the Black Sea, Sea of Azov, and the Kerch Strait. It seems difficult, it seems complicated, but the core of the disputes is basically the disagreements between two countries. So in the case of Chagos, when the Mauritis were against the United Kingdom, there was some part of the territories which United Kingdom claimed their own, and the Mauritis tried to defend itself and went to the tribunal and asked basically to the tribunal ruling was that the core of the disputes was that Mauritius asking not to solve the issue related to the interpretation of or application of the United Nations Convention, but rather to settle the sovereignty dispute between two countries. So the case was actually rejected. Further, Mauritius asked the ICJ about advisory opinion on the sovereignty issues. And the ICJ made a decision, and then Mauritius went to another dispute between with Maldives, and on those disputes, which the decision was available just recently, like in January this year, 2021, it stated that the ICJ has advisory opinion has a legal effect. So basically, it helped to prove Mauritius in certain position that. In the previous dispute between Mauritius and United Kingdom. This, I think, dispute would be really relevant to Ukrainian experience, despite the fact that the the objectives, the situations a bit different, it still shows that there is a, like, even when the tribunal rejected because of the sovereignty issues, which actually Ukraine has now because of the occupation of Crimea. The thing is very simple. Like, there is a tribunal about the law of the sea. It can rule over the land issues. It cannot go like further than like saying. And this particular, the case of the Mauritius shows a slight a light, like, you know, the light in the tunnel. So I'm mentioning this, like this particular two cases, two disputes, to show that the, like, on this example, Ukraine can elaborate on the its own, like, submissions, and to elaborate on the, like, on the dispute itself between Ukraine and Russia. So, and to like to find the solution, how actually Ukraine can protect its like maritime rights in the sea, and like, just, you know, one more thing in favor of Ukraine, that look, the Crimean occupation was illegal, etc., etc. The interesting thing that the Mauritius submitted its dispute in 2010, and at the moment is like nearly 11 years passed, and still the dispute is not entirely solved. So it just shows that it's a long procedure, it's a long way, but it doesn't mean it's will be unsuccessful. So, and from the perspective of the dispute, the finding of the dispute between Mauritius and Maldives, it's really worth reading for those who are who goes into details, and to see that even the advisory opinion of the ICJ, it doesn't have binding effect, but according to the decision, it has a legal effect. And if it comes to the preliminary decision of the tribunal and the disputes concerning Ukraine and Russia, it said that there is no binding decision about the status of the Crimea, and there is neither even the neither decision which has a legal effect. So, for example, the resolution of United Nations General Convention has advisory character. It's not binding. It's moreover, it's mostly in hortatory language, and it also seems like more having political nature. So you can see, like, there's a huge weak point of the Ukrainian arguments, and then you find out about this particular cases and seeing, like, okay, maybe we have to do something more. Ukraine has to do something more to be able to protect its interests.
Speaking about the procedure and the dispute, is it allowed or is it practiced within such international tribunals to use precedent law? For example, when you refer to the decisions in other cases, but which have similar or identical grounds and objectives, or it's not the case here?
Oh, that's exactly the case. That's extremely exactly the case, that the tribunal, like, basically the authorities under the convention who are able to decide about the convention, first of all, they have jurisdiction. It's 2018 the article itself, if I'm not wrong, and it states that it has jurisdiction over the disputes concerning interpretation or application of their convention. So there is like, we have convention as a source to apply the rules, but there is decisions already made, the decision who already made interpretation or show the way of application this convention. So the tribunal, they're constantly using this decisions. They're also using the ICJ decisions. So there's a established practice of using the previous decisions. Towards, from the scientific point of view, it's also possible to use the commentaries of, because before the UNCLOS 1982, there were a couple of conventions which were before, So they're also using the commentaries of the the working committees on this conventions, how the UNCLOS were made. So, for example, the sovereignty issues under the UNCLOS, whether they're the writers, drafters of the convention were intent to include this dispute into the meaning of the convention or not. So, no, that's how they work.
Okay, great. Thank you for this explanation. Are there any maybe more cases or examples of the disputes that are also worth to know about?
Yeah, sure. The in for Ukraine, it's the two main disputes for Ukraine, which is and the one I mentioned, and there were also another one about the case concerning the detention of 3 Ukrainian naval vessels.
Yeah.
And I think everyone in Ukraine, all Ukrainians, I know are well know the case about when the Ukrainian seafarers were returned from Russia, etc. And it's actually we know all Ukrainians are here. There's aggression of Russia, everything there is aggression. We are in state of kind of war. But in this case, Ukraine took the line that there is no aggression between Ukraine and Russia. There was a peaceful operation between Ukrainian naval vessels. It was made in the perspective to allow tribunal have jurisdiction over this of this case. So the tribunal decided to release the vessels as well as Ukrainian seafarers. And in this point, the Russia was arguing that no, that was kind of a military operation. There was something going on. And from the perspective, it's interesting to research more and to learn more about it. What the impact in the future will be of the Russia saying this in its argument, and Ukrainian saying this one. I know that
it's kind of a basically stating and agreeing that the military or I don't know, some military actions were actually taking place, even though they all the time they claim that no, this is nothing relevant to the war or any military operations from Russia Federation. Is just some internal conflicts in Ukraine.
Yeah. The I don't exactly. The Ukraine was claiming opposite, and Russia was claiming this one. It's interesting from the perspective of to see in the future with the tribunal decision, because this is a problem of inconsistency. To defend your right, to a certain extent, you have to be very consistent in what you are telling and what you are saying. So there's both sides were inconsistent with the viewpoints. I guess it was beneficial for Ukraine to say that, to be able to release the vessels and to find the settlement of the dispute. So the Russian Federation were obliged to release the vessel as well as the people. But we don't know. I know there is in the investment arbitration, the Russian Federation, where there was some disputes also in the international authorities, and they were claiming that we don't accept this particular treaty because it's violating our national rules. And the tribunal released a decision telling we have that you have the perfect case example of Crimea accessing Russian Federation when it's was not in not under your national legislation, but was in relation, and only after it was become legal, and you were accepting it. So you cannot say that from one this case we're not accepting and this case we're accepting. So it has to be inconsistent. So I hope and I think it will be very interesting for the tribunal to also to evaluate this circumstance and to rule the decision.
So the proceeding in this case is still ongoing, and we don't know yet what are the interim decisions.
It's difficult to say that it's ongoing or not. The dispute concerning coastal states' rights in Black Sea and Sea of Azov is ongoing. It was because the tribunal ruled it was a preliminary decision.
Mm-hmm.
And and preliminary decisions state that all submissions related to the coastal states' rights and obligation are not under the jurisdiction of the tribunal. So the huge part of the submission of Ukraine, like just think about that properly. The Crimea Peninsula has its maritime zones. So as we were talking more about them, they're all has like they're all regulated and they're all based on the land. So all claims in the exclusive economic zone related to the territorial sea of which are like in the territory sort of like based from the Crimea are rejected by the tribunal because it has lack of jurisdiction.
Mm-hmm.
And the case right now, which is going on, it's this the like not all like a lot of, but not all submission are rejected by Ukraine. So right now, the Ukrainian writing memorandum based on other submissions, and there's still a lot. There is still environmental issues related to environmental issues related to the like to the Kerch Breach. So there are some issues which are still ongoing, and the procedure that started from 2016 and will be ongoing for quite a while, like, I guess. So
Okay.
yeah, so it's still ongoing, the procedure.
Mhm.
Okay, wow. What can I say more? That was quite a conversation, I would say. Literally, I personally learned a lot, and I believe that the audience will learn a lot as well. I have maybe the last question for you. As an expert and researcher in this field, what sources or anything like that would you recommend to anyone who would like to learn a little bit more about international law of the sea, where to start from, what to research, what to read, and so on?
I would like to specify that to international law of the sea is like a lot of about the conventions. So just the first one you have to read and to analyze is UNCLOS. Secondly, if you're getting into UNCLOS, you may also read the decisions, which and to see like what is ongoing situation. I would recommend some English written books in international law of the sea. There is some Ukrainian language books, but I like to be honest. I think the convention is in English. The decisions are made are like which are from from the court tribunals over this question is are in English. So I would recommend to read just the pure source of the thing. Yeah.
Um,
The the last point that I would like to mention that. There is also in the law of the sea. There's still so many issues which are not solved. There are so many like issues which are under the question, and there in general the field is very interesting to discover even deeper and more. For example, the regulation of the Arctic. We have like it's all well known the climate changing. There is ice melting, so how its impact on the waters because the baselines are changing and etc. So it's like it's a like huge field of exploration, a huge field for learning.
Great, thank you. And I would probably ask you to provide maybe several links to the sources that you recommend, probably the convention itself, where one can find it, and maybe some cases that you would also recommend to read and know about. So yeah, we will just leave the links to the description of this episode. And for everyone, I would like to remind that. You can listen to this episode on several platforms, namely SoundCloud, Castbox, Google, Apple Podcasts, and Spotify. Please do subscribe. Please like, share, and comment the episode, and also recommend it to your friends, family, anyone who might be interested in it. Also, please subscribe to the Telegram channel of the podcast, even though it's in Ukrainian. But like Olesia said, the convention and the cases are in English mostly, but my Telegram channel is in Ukrainian, so it's a nice chance to learn some Ukrainian as well, or at least to practice it if you are a foreigner and you would like to learn some Ukrainian as well. Yeah, so support us. That's probably the best gratitude to the content makers and podcasters. Thank you so much, Olesia, for your time and for your expertise. It was very interesting and exciting to hear about some aspects of international law of the sea. And
Thank
you,
you.
everyone. Mhm.
Thank
Yeah.
you, thank you everyone as well. That's for sure. Thank you for listening so far as well. Thank you for like ability to talk and like feel free if there is any more questions or etc. Either you either I could provide some more details. So also feel free to reach me in any other available sources. So yeah, and listen to podcasts. Like this is not the last one. So listen to the podcast. It's amazing, really.
Thank you so much. I'm so pleased to hear such a great feedback. So yeah, everyone, thank you again. Thank you, Olesia, and learn about international law of the sea. And take care. Bye bye.
Bye bye.